Welcome to Peachtree Injury Talk with attorney Jordan Jewkes.
Welcome to Peachtree Injury Talk with Jordan Jewkes. Jordan strives to give injured victims a voice and provide strong advocacy against an often broken system. I'm your host, Katie Roberts, and today's episode is The Fine Line of Fault: How Comparative Negligence Shapes Your Personal Injury Case. Thank you so much for being here today, Jordan.
Thanks, Katie. I am really looking forward to being here. This is, despite the way it sounds, it's actually really cool stuff.
I think it's interesting. So I have a question just to kick us off. I'm not well versed in personal injury. So could you explain what comparative negligence means in the context of PI law in Georgia?
Yeah, absolutely. Comparative negligence is one of those words or phrases that you hear and you just sort of say, what? It's definitely a legal term. And to break it down, it essentially means if someone is injured, right, and they're making an injury claim, comparative negligence is the idea that they may have some fault in the manner that they were injured, right? Or in other words, they may have some contributory responsibility. They may be partially blamed for what happened, for how they got injured. And sort of the classic scenario is, were they speeding at the time of the car wreck? So if they were speeding, then perhaps there's an argument, a comparative negligence argument, that because they were breaking the law or they were negligent themselves, then their money damage or the reward should be lowered because of their own fault.
Interesting. So does that mean that when you are utilizing the comparative negligence dynamic, is that something that you do proactively as you see a case, or once you have time to review the case, take a back step and say, hey, we need to look at this from where you could be at fault?
Yeah, I mean, really good question. And the answer is yes and yes, I think. And what you have to do is first get an understanding of what the law in Georgia is. And again, it's a little bit of a mouthful, but the law in Georgia is such that if the person who's claiming the injury is more than 50% at fault, right? So if they have a larger share of fault than the person who they're saying caused the injury, or what we would normally call the defendant. So if the plaintiff in this sort of the traditional setup is more than 50% at fault in Georgia, you cannot make a recovery. That plaintiff cannot make a recovery. It's called comparative or modified comparative negligence is kind of the way the law says on paper. And so the idea is if your own negligence was the greater cause of the injury or the wreck rather, then you yourself can't recover for it. So if you rear end someone, and this makes sense if you think about it, if you rear end someone and then the law generally wouldn't allow you to sue the person that you rear-ended, saying that they stopped on their brakes too quick or something like that, and you couldn't sue them for an injury claim because more likely than not, you'd be more than 50% at fault for causing the wreck.
That's so interesting. And I'm wondering, is there like a standardized weight to allocate percentages for that? I mean, if it's that 1% that puts the defendant or the plaintiff at fault, splitting hairs, is that per law firm or is that just standard?
No, I mean, the law simply says, you can't have the weight of fault at it. And so generally speaking, the courts will determine that to be 51% or more. And really the way that gets measured, right, the percentage is only through a jury. So if I say, if I'm advising my client and I say, well, I don't think you have greater than 50% at fault, we could go try the case. And then the jury, after hearing the evidence from our side and the defense side, the jury could disagree with me and say, we think she was 60% at fault. And if they make that finding, then my client, no matter the size, the severity of her injuries, she can't make any recovery because she's more than 50% at fault. So really the jury is the only one that can make a determination, the binding determination, that percentage.
So when the percentage is so close that you can't confidently say I can't say your fault is going to be at or below 50. I mean, do you highly advise going to trial?
I mean, every case is different, but I think you're asking the right question. If someone comes in and there's a lot of issues and questions surrounding who's at fault, my office takes a great risk or a greater risk in determining and taking that case and agreeing to put our resources into it. And so there's a lot of factors that go into that question. And very often, though, we may have an instinct or a gut feeling about a case, because what we know on day one is very often different than what we know on day 20 after we've done our own investigation of the case. But yes, if my gut tells me, you know what, this client or potential client is 50% at fault, if it's right there on the line, it's something that I've got to talk to the client about before taking and letting them know, there's a good chance, a very strong chance, that we can put a lot of time and effort in this and there can be no recovery.
I mean, literally high risk, high reward.
Yeah. And again, you're asking a good question because, or pointing out an important concept there, because if someone is just, has very minor injuries and we're going to have to spend all of our time trying to prove that she wasn't at fault, it becomes a question of, is it worth all the time and the resources that we're going to have to put into it when it's likely the client make a recovery? And so on the other side of that coin, though, is if someone is very seriously injured and maybe the other party is claiming they ran the red light, we have a much greater incentive to put some time and effort into that to really fight for this injured person. Every case is different.
Yeah, I mean, it's super fascinating because if you do use those resources and the case goes to trial rather than settling outside of court, yes, you could make a lot more money for the client, but the resources, the hours put in, there's that fine line of deciding whether it's worth it based on what you've said, the injuries and who's really at fault.
Yeah, no, you're exactly right. And so when we take a case, we have to sort of make a determination, a gut reaction at the beginning. And sometimes we'll take a case on the condition that after an investigation, we want to be able to see greater evidence that our client does not have fault, or if they have fault, that we can likely successfully argue that the fault is minimal, or at least significantly less than 50%. If we're going into a trial and we're trying to argue a 50-50 case, that's a tough one for us. I mean, we'll do it, but that's a tough one. So, I mean, we've had cases where this comes up that, and every case is different.
Well, Jordan, I just have to say that I do believe you're selling yourself short calling these gut reactions, when in actuality, this is years and years of experience and historical data that you've been able to really understand when you see a case quickly, if this is going to be worth taking to trial or not.
Yeah, I mean, obviously there's a lot of experience behind what I would call a gut reaction. But yeah, I mean, the longer you do this, the more experience you have and the better you look or you get at making sort of these decisions in the blink of an eye. And it really is, though, a gut reaction where you can start to say, if there's not a witness, if there's not video camera evidence, if there's not statements made that clarify this immediately after the wreck, it gets really hard. But, at a busy intersection in a metropolitan city, and sometimes there's more likely video evidence that can be secured. And also, sometimes you go talk to the police officer after the event, and the police officer says, well, look, I compiled the police report, but I didn't cite either of the parties. But in reality, the driver A or driver one was clearly at fault, not the other driver. And sometimes the officer, if he's got a good decision and remembers the accident, and again, the sooner you talk to him, the better. But if he's pretty firm or she is pretty firm on who's actually at fault, even if they didn't assign fault on the police report, we can say, yeah, we'll go ahead and take this, and we'll get the police officer to give sworn testimony that the defendant is at fault. So no, I appreciate the compliment. These can be tough, but the experience helps to make a determination.
Yeah, absolutely. It's just the instinct, not nature versus it's nurture of how you've learned and progressed in your practice, and that's what drives the gut feeling.
Yeah, and we've taken a lot of cases where another firm may have made a review of it, or maybe a firm that doesn't specialize in personal injury, or even sometimes a bigger firm that just wants easy cases, right? And they'll turn down cases that are a little more tricky or complex, or maybe have an at-fault question, or what we call a liability question. And so we'll take those, we'll spend some time on them. And if our gut says, hey, look, we think there's something here, we'll take that. We want to help people. That's the goal of our firm, is to help people get back to where they were prior to the car wreck. And we don't mind fighting for that. So these cases often present a fight, though, and they're usually not settled without some type of lawsuit being filed and some depositions being taken.
I had a friend who went through personal injury, and it was years and years because of the defendant was throwing countless loopholes for. It was horrible. So, Jordan, let's just paint a picture. Let's say I got in a car accident. I don't know who is at fault. Maybe there were multiple cars, but I'm severely injured. What is the first thing that I should do? Either gathering evidence, who should I call? What do I need to collect in order to protect myself through the years or months ahead?
Yeah, I mean, and I get asked that question all the time. And there's certainly some things you want to do. Obviously, make sure your body's taken care of. Take some photos at the scene. Try and document what you can. And when, get medical treatment for anyone who may be injured on the scene. Call 911 is one of the best things you can do. But there's also some don'ts. And I would say one of the most important don'ts is don't admit fault.
Don't say sorry.
And don't say sorry, because if you're unsure of who's at fault, let the investigating police officer, the one that is first at the scene, do their job. And sometimes, we love representing good folks, good community members, and people that contribute to society. And very often those people are the first ones to say, hey, look, let's find a solution here. I'm sorry this happened. And those words can sometimes be construed as an admission of fault when really you weren't at fault. In fact, Katie, we handled a case not long ago where our client was driving on a road in our area, and the car in front of her stopped suddenly, had a green light actually, and just stopped suddenly and ended up turning, even though kind of turning from the wrong lane. Well, our client was able to slam on the brakes. She wasn't following too closely and stop in time. Unfortunately, the driver behind her did not stop in time and rear-ended her. What was one of the unfortunate parts of the case is our client got out and was a super nice person, just as nice as you can be. And she said, I'm so sorry, this person in front of me stopped. And she said that to the person who hit her. And so she ended up having pretty significant back injuries from that. And so one of the defenses in that case, one of the very first things they did was file a legal document saying that my client is contributory or comparative negligence. It's actually a document called a notice of non-party fault, and says this lady that slammed on her brakes but pulled away from the scene, that again, no one actually impacted her. They actually said that she was the main person at fault and not the guy that actually hit my client. So anyway, that made that case much more complex, but we did take it and we got a good recovery for her, but it took a while to do it.
Wow, that's amazing. I'm glad to hear how much you advocate for these people, and save them so much heartache, and hopefully they're on the path to recovery much sooner. I've been seeing things more and more about the kind of the situation you described, but intentional, where someone stops in front of you and then their co-conspirator is behind to cause an accident. Do you see those kind of cases pretty often?
The short answer is no. I have seen some of those videos on TikTok or, on social media channels, whatever they may be. It's actually hard to believe that someone actually does that. Yeah, and in fact, I saw one where this is right up the alley of what we're discussing, but I saw one on TikTok where a lady or drivers of a sedan pulled in front of another vehicle and then slammed on their brakes. When the vehicle that they pulled in front of stopped in time, the other vehicle in front actually put their car in reverse and went and rammed using the back end of their vehicle into the oncoming vehicle. And then the people got out and they're doing this and saying, "Oh, we were injured," and they purposefully hit them, and it's all.
And they realized there's a camera. I saw that.
Yeah, there's a dash cam.
And they turned in and got in the car.
Yeah, that's exactly right. They kind of saw that, but that case is I guess a good example. I don't know if there's anything good about that, but it's a perfect example of comparative negligence in action, because they would be 100% at fault for causing the wreck, not just 51%, but 100%. And so they would not be able to make a recovery, because essentially, not only did they do that fraudulently, which is against the law, obviously, but they were trying to make it look like it was a negligent act. And just in terms of what we're talking about today, they had complete fault, so they wouldn't be able to make any recovery. But to answer your original question, we really don't see that much. I mean, I've never knowingly represented a client that was faking an injury or that was trying to claim more than what they were, owed in this type of situation. It doesn't happen.
Follow-up question. Do you recommend that everyone has a dash cam?
Short answer is yes. It happens all the time. And a lot of cars these days have dash cams built in. Like they have them in there. They have video. But yes, I mean, a dash cam can cost anywhere from, $20 to $100, plug and play. And usually they're so easy. If you press a red button on, or the engage button on them, they'll automatically save the last minute or 5 minutes, whatever it is. And I've seen so many times where a dash cam made liability or who is at fault very, very clear following a wreck or even following like a citation when they were pulled over for something. So yeah, Katie, I mean, that's a great point. Get a dash cam, especially if you're prone to car wrecks. I know that sounds silly, but get a dash cam.
Some people are. Or, I mean, I live in Dallas and there are crazy drivers. So yeah. I might order one later this afternoon. I know I've kind of steered away from the questions, but I was just so fascinated by what you were telling me. I'm going to get back on track now.
No, that's totally relevant. A dash cam will help clear you of fault if you don't have fault. That's a really good point.
Well, I will be purchasing. How do insurance companies handle cases where both parties are partially at fault? Is it typically like a fair settlement, or is there negotiation in certain situations?
Yeah, well, of course, every case is going to be a little bit different, but the insurance companies are usually the first one to pull out or to claim comparative fault. And they'll say, well, we think that your client in our negotiation process or fairly early on in the process, the insurance company or their adjuster will reach out and say, you know what, we think your client's 25% at fault, which is very arbitrary. How do they get 25%?
I'm shocked an insurance company would do that.
Right, exactly. They have just such good history of fairly taking claims on, right? Or sometimes they'll say, hey, we have one right now where they've said, hey, we believe this is 50-50 or that your client is 51%. And so I always tell folks, the insurance adjusters are not the final arbiter or the final decider of the percentage of fault. Only the jury is. And along the same lines, I'm not either. I can give them my best professional guess. But until that case is in front of a jury or perhaps a judge, but usually a jury, no one knows the exact amount. But yes, to answer your question, the insurance companies love to say, oh, your client's partially at fault. If she hadn't stood there for so long, she wouldn't have been rear-ended. Okay,
Well, in a perfect world, what impact does comparative negligence have on other types of damages like pain and suffering, emotional distress? Second part, if someone is injured in a multi-car accident, how does comparative negligence come into play when determining the degree of fault for each driver involved?
Yeah, and I'll try and answer those questions the best I can. The comparative fault can reduce, to answer your first question about the pain and suffering and the damages part, the way we usually evaluate these is we'll say, if we know that our client had some fault, right? And we don't know how much a jury would award, but let's just say, for example, 25% at fault. For whatever reason, it doesn't really matter. The way we evaluate these and the way that the jury would kind of be instructed to evaluate is to say, what's the total amount of your damages? Your pain and suffering, your medical bills, your future pain and suffering, your lost wages, all these things, and add all that up. And let's say it's $10,000, just to use a simple number. If the jury said, well, we also think that the plaintiff, the victim here had some fault, let's say 25%, then the jury would take that total number, 100%, which again, for sake of our podcast today, let's say that was 10,000, then they would subtract 25% off that, which is of course 2,500. And so the verdict would be 10,000 minus 25% against our client. So my client would be entitled to a check of $7,500 from the other driver's insurance company. That's how it kind of works in terms of pain and suffering and claims for damages, how comparative fault works into that. And so we have to take that evaluation into the process. The other question, how do you, when there's multiple cars, how do you determine fault? It gets really complicated. There's not a simple answer to that. I will just say you have to be very careful. You have to pay attention to a lot of detail, and you often have to do a very good investigation. And again, if it's a rear end, kind of one of these chain reaction rear ends, usually the car at the very end, that the one who caused the wreck in the first place, usually they have the bulk, if not all of the fault. Because what often happens is they'll rear end the car in front of them, and that car will be pushed forward to hit that person. And usually there's very little fault of the end car, what we call the target car. They're just sitting there usually when they get rear-ended. But beyond that, it gets really complicated depending on the scenario.
I feel like we could do an episode on multi-car accidents alone because of how challenging dealing with multiple insurance companies, dealing with, previous record of accidents. But
yeah,
I'm not well versed. You are, so I won't go further.
Yeah, I mean, the best advice I can tell you is if you think you may have fault, or if you think there may be other vehicle or other drivers who caused, if you think there are multiple bad actors or people that caused your injuries, the best thing you need to do is go talk to an attorney who will take the time to look at it and properly analyze it. Because the longer you go trying to do that case on your own, and I'm not saying it's impossible, but the longer you take to try and do that without gathering the right evidence and sort of preserving the arguments, the less likely you're going to be able to make a full recovery. And sometimes, in fact, it happens very often, we have to sue not just one person, two or three. We just have to sort of say, look, you all are going to point fingers at each other, all the defendants, which is fine. I have no problem with that. Just don't point them at my client if they were the last person to get injured. So
that brings us back to one of the first questions I asked is what to do first thing after getting in a car accident, and taking as many pictures, act as quickly as possible. I love that. And Jordan, I've sincerely enjoyed speaking with you today. That brings us to the end of our show, and I greatly appreciate your time.
Yeah, thanks for having me again. We've enjoyed it. And again, give us a call, free consultation if you have any questions about any of this.
Absolutely. And to everyone watching, thank you for tuning in to the Peachtree Injury Talk with attorney Jordan Jewkes. For more information, to connect with Jordan, you can visit jewkesfirm.com, and be sure to hit that like and subscribe button. Leave us a review in the comments. See you next time. Thanks.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.